Hi, I'm David Vicknair with Scott Vicknair Injury Lawyers, and today we're talking about 5 things not to do when talking to the insurance company after your car accident. Number 1, never do not discuss your injuries with the bodily injury adjuster before retaining an attorney. So, for example, after you're right in a car accident, there will be multiple adjusters who will reach out to you. One will be a property damage adjuster who's adjusting your property damage on behalf of the other driver if they're at fault. Another will be the bodily injury adjuster who is adjusting the bodily injury part of your claim. Those 2 adjusters have very distinct roles at the insurance company and very distinct responsibilities, and you obviously want to talk to the property damage adjuster sooner rather than later because you want to get your car fixed. So you want to cooperate and provide different estimates, photos of damage, and things like of that nature to the property damage adjuster so they can adjust and hopefully fix your car. And if they delay or not responsive or take too long, if you have collision coverage on your car insurance, you could make a claim on your collision coverage just to get your car fixed sooner so that you can have it to drive to and from work or for your daily appointments and your daily life activities. And then your insurance company will what is called subrogate, but really just make a claim against the other insurance company to recover the money back and then reimburse you your out-of-pocket money for the deductible, whether it's $250, $500, or $1,000 from the other party's insurance company. So either way, you can talk to the property damage adjuster. But number 1, you do not want to talk to the bodily injury adjuster to start. Focus on just talking to the property damage adjuster. But then number 2, do you talk to the bodily injury adjuster without a lawyer? The answer is no, do not do it. There are many reasons for this. The bodily injury adjuster for the insurance company is doing a job. They have a job and their client is the insurance company. They're asking you specific questions which may seem innocuous, but have done this for many years. We know that a lot of those questions, not all of them, but a lot of them are aligned to try to elicit certain responses from you that could potentially be used against you in your injury claim down the line. And what are one of those things, which is our tip number 3? Do not assume that you are not on a recorded line. Louisiana is a one-party consent state, meaning that only one party has to consent to being recorded in a conversation between 2 people. And so while most insurance companies will notify you if you're talking to the bodily injury adjuster without an attorney that you're on a recorded line, some may not. And technically, they're not legally required to notify you that they're recording your conversation. So do not assume that you are not on a recorded line. That is tip number 3, and a big one, because if they record you and you say certain things that you think are innocuous or not a big deal or just honest in the moment, for example, oh no, I'm not hurting at all, I have no injuries. Well, you may not be hurting that day, but you may have been hurting the day before and the day after, and then that comment is used against you later on because it's been recorded, and it could be used to make you look like you're being dishonest or not honest about your injuries, when if you really were intending to communicate it as being limited to that one point in time. So don't assume you're on a recorded line. And as we talked about in number 2, do not talk to the bodily injury adjuster, if at all possible, without an attorney, because the attorney can know and have an objective finding when listening to the call and understanding what's being asked of you, whether or not to end the call, to instruct you not to answer, whether or not to even let the call happen, okay? Because what happens when you have a lawyer is we send out a letter of representation to the insurance company, and they're not supposed to, and 99% of the time they don't. Sometimes they do, and we cause mayhem when we find out that they do it. But once they know you're represented by an attorney, they're not supposed to discuss your claim with you without the attorney's consent. And most of the time, we're not going to allow you to talk to an adjuster pre-suit unless there are specific circumstances that we deem it is appropriate. Number 4, be careful about any indication that you give to the insurance company. We briefly talked about it before, about the pain you're experiencing on the day that you talk about your injuries. So this is one of those things that injuries and pain are very fluid. Any of you who've had an athletic injury, a workout injury, an injury in a prior claim or incident, whether it's like a slip and fall, offshore incident, car accident, whatever it is, you know if you suffered an injury before that your pain never stays constant and the same. And so weather conditions, how much sleep you get, how hard did you exert yourself the day before could result in you feeling a certain way the following day. And so if you say, hey, the first day after the car accident, my pain was only at a 1 out of 10, meaning my pain was not that bad. But after the adrenaline wears off and time passes for the next 2 or 3 days, because all of a sudden you wake up and you have severe neck pain. That is not an irregular occurrence. And in fact, that's quite regular. A lot of people don't necessarily always feel pain immediately after the collision because of the adrenaline running, because of them living in the moment, but they wake up later in the day, the next morning, the day after, all of a sudden their back, their neck, their knee, whatever it is that you've injured or hit starts to really feel bad and be in a lot of pain. And so you want to be very careful about communicating anything to the insurer in your claim about pain in a specific day, because as an attorney who's been doing this for a while, and all of our attorneys here, we're very cognizant of trying to protect the clients from walking into trap and making the mistake of saying, oh, I feel fine. Well, you may feel fine today, but you probably didn't the day before, and or it may not the day after. And that's one of those human instincts and elements of we do, especially in South Louisiana, we're very tough, resilient people. You want to diminish certain things and make it feel like you're fine when even, maybe the day before you were in excruciating pain, but today you feel pretty good. So you're like, oh, I'm fine. That can be used against you. Number 5, last but not least, you should never, without an attorney being involved and advised, sign any authorizations that the insurance company provides to you. What do I mean by that? They may send you a HIPAA if you're unrepresented in your claim process. Say, hey, we need you to execute these HIPAA so we can get all your medical records. That's fine, except if you cannot give them, and we never let clients, nor does the law in Louisiana require, that you give a blank HIPAA authorization, meaning not listed to a specific provider during a specific time duration period. So if you just sign a blank HIPAA, and that's just one authorization, for example, they then can write in medical providers, they can get records from 20 years ago that may have no relevance nor be reasonably calculated to lead to the discovery of admissible evidence in your case if it ever made it into a lawsuit. They can just fill things in and go get medical records, and if you sign that blank HIPAA, you've kind of given them the authority to do so. So never fill out an authorization without an attorney involved, because your attorney is going to know what they are or are not entitled to and how to limit the scope and the duration of any authorization that you may be required to provide the insurer. And it's not just HIPAAs. We're talking about cell phone authorization, social media access. They're going to want all those things, the things that kind of may be brought up in litigation. They could potentially ask you to sign some of those things and give them that authority to look into things in a pre-litigation claim before a lawsuit's been filed. And you could innocuously sign something and not even understand that you've kind of given them carte blanche to look into medical records from 23 years ago at an unrelated medical provider, or at different things in your cell phone records that they have no relevance or connectivity whatsoever to your auto accident, offshore incident, or anything of that nature. So if they request you to file an authorization, the answer is no, and hire a lawyer who can advise you on what you should or should not provide them. So those are 5 tips, 5 things that you should avoid doing when dealing with the insurance company and making an insurance claim. And if you've listened along this far, then we hope you'll follow along to the next video where we're going to talk about 5 things you should consider before filing a lawsuit for your personal injuries. This has been a great discussion. I'm David Vicknair with Scott Vicknair Injury Lawyers. Thank you for listening. Everybody hears the word settlement or trial court verdict, they get all excited. But it's not always that simple. Here's 5 things that you should consider about your personal injury